Hello and welcome to today's webinar on wrongful trading. My name's Eleanor Stevens. I'm an insolvency practitioner with over 25 years experience and I'm working today as a consultant in private practice. For several years, I was a partner in a firm in the Southeast, acting in all aspects of insolvency. I then joined LexisNexis to set up their Lexis PSL product for insolvency professionals. But for the last few years now, I've been working as a consultant insolvency solicitor, as well as writing for publications. I often work with directors in advising on wrongful trading claims, mainly how to avoid them, but also, if necessary, in defending them if a claim is brought against them. I also work with insolvency practitioners on wrongful trading claims brought against directors. So today we're looking at wrongful trading, what it is, what it involves, and also what case law says on the subject. In particular, we're going to be looking at what is wrongful trading and who can be held liable for it, who can bring a claim for wrongful trading, what is needed to be successful in establishing a wrongful trading claim, when does optimism become unrealistic for directors. We're going to look at the penalties for wrongful trading. And we're going to look at some examples of wrongful trading, including relevant case law and recent case law. And we're also going to look at a new claim of misfeasant trading and how does this differ from wrongful trading. And finally, some tips for directors to avoid liability for wrongful trading when they're facing financial difficulties. So what is wrongful trading? Wrongful trading is one of the more tricky insolvency offences found under the Insolvency Act for an insolvency practitioner to bring. And this is because it's quite hard to prove unless there's very clear evidence of wrongdoing. It's often not easy to establish for a claimant who has to go back through a company's record to try and reconstruct the position, which is what insolvency practitioners will have to do. Okay. As a result, in my experience, these proceedings are not taken with anything like the same frequency as other offences which are more clear-cut, such as preference transactions or transaction at an undervalue, for example. So let's take a look at what is wrongful trading. So wrongful trading is a claim which arises under the Insolvency Act 1986. It's under Section 214 when a company or a limited liability partnership has gone into liquidation, insolvent liquidation. And Section 246ZB when a company or a limited liability partnership has gone into administration. So it applies to both types of insolvency processes. Sections 214 and 246ZB are identical. So if I mention Section 214 here without referencing Section 246ZB, then please take it as read that anything I say applies to both sections equally.